Almost everything in modern so-called constitutional law is based on a myth. And it goes back to Chief Justice John Marshall in his famous 1803 opinion of Marbury versus Madison. And in this myth, we're told that not only did John Marshall invent the doctrine of judicial review, but he also established something bigger than that, something we call judicial supremacy, where one branch of the government gets to tell the other branches what the Constitution means. They're superior to the other ones. They can order them around, and they can even tell the states and the people what to do as well. So on this episode, we're going to smash that myth to pieces and reveal the true story behind Marbury. But first of all, before getting to that, welcome. And thank you for joining me here on the path to liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Monday, February 24th, 2025. So let's start out with the myth, the textbook version of Marbury versus Madison. You can find examples of this all over the place. It's taught basically everywhere. But we'll start here with the official website of the federal court system of the United States, uscourts.gov. They teach this myth as well. What a surprise. Surprise. The judiciary is supreme over everybody, and so the courts tell us that they're the ones in charge in essence. But here, for example, of how they put it, from a lesson plan on Marbury versus Madison that they give to schools for grades 9 through 12. So they're trying to teach them relatively young. I mean, we should be teaching people much younger than this, but they're going pretty young on pushing the myth. And this is how they explain it. When it comes to conflicts, someone has to make the final decision. Interestingly, the writers of the Constitution did not determine which of the three branches of government would be the final arbiter of constitutional issues. Quick aside, for those of you who've watched or listened to this show for any amount of time, you know why they did not add that, because they didn't want anyone to be a final arbiter and therefore supreme over everybody else. But today they write, it is assumed that the courts are the final authority on such matters. Marbury versus Madison firmly established that the Supreme Court of the United States has the power to determine the constitutionality and validity of the acts of the other two branches of government. A concept that is a fundamental characteristic of American government. But this was not always the case. It started with Marbury versus Madison. They said this decision created the doctrine of judicial review and set up the Supreme Court as the chief interpreter of the Constitution. And in other words, this is basically a summary of what they're telling us. This textbook view, this modern myth of judicial supremacy says that when the Supreme Court shares an opinion on the constitutionality of anything, it's not an opinion. It's a ruling, and it's binding law. The Supreme Court then dictates the meaning of the Constitution to the other branches of the federal government, legislative and executive, but also the states and the people themselves, and everyone is bound to follow their opinion until they change their minds on what the Constitution means. And as a result, the court's power over constitutional interpretation has really been morphed into something that was never, ever created by the founders, by the framers, and is now regarded as one of the main pillars, if not the main pillar of the entire system. And judicial opinions, then, judicial rulings as they treat them, are now on par with or even superior to the text of the Constitution itself. And that's pretty problematic. Here from his great law review paper, The Irrepressible Myth of Marbury, Michael Stokes Paulson says, nearly every feature of the myth is wrong. Just straight up. So let's first start out with the myth that Marbury versus Madison created judicial review. This is just nuts. I can't believe that this persists. Paulson puts it like this. For openers, Marbury versus Madison did not create the concept of judicial review, but in this respect applied well-established principles. It was already something that was going on. He said the idea that courts possess an independent power and duty to interpret the law, and in the course of doing so, must refuse to give effect to acts of the legislature that contravene the Constitution, was well accepted by the time Marbury rolled around, more than a dozen years after the Constitution was ratified. He continues, such a power and duty, we keep hearing the word duty, that's a big part of what went down there, was contemplated by the framers of the Constitution, publicly defended in Hamilton's Federalist 78, as well as other ratification debates, and well recognized in the courts of many states for years prior to Marbury. It was not created by Chief Justice John Marshall. We can have all kinds of other complaints about Marshall, but definitely not that. Why not just give him trouble for the problems that he did create? But anyways, hear from Rob Natelson. Marshall did not invent judicial review. He simply applied a principle that was already expected, especially during the ratification debates, and was already well established and being used. And Rob says, during the ratification debates, both Federalists and Anti-Federalists assumed that the courts would have power to void unconstitutional laws. Now, you might be thinking, what? Isn't that them being on the top of the food chain if they're voiding them? Well, if you understand how it plays out between the difference between judicial review and judicial supremacy, which hopefully this whole episode will explain, then that is not an alarming term at all. Anyways, Rob says probably the most famous example is Federalist number 78. That's Hamilton, who said this: the complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and the like. Then he continues. Limitations of this kind can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all the reservations of particular rights or privileges would amount to nothing. Again, you see here during the ratification debates, and this is Hamilton kind of late in the game during those debates, not really influential on the original legal meaning, but he's pointing out here that it's not just an idea. It's expected that when a case comes before a judge and the judge reads what's going on and then reads the Constitution and says, like, look, this doesn't kind of go with the Constitution. It's their duty to say that it's unconstitutional, to declare it void. Again, it's their opinion, but they're supposed to do something. Now, Hamilton was far from alone, and he also, it sounds like he's pushing a judicial supremacy. For those of us who's read through this, we know that he also rejects that, and I will get to that in just a few minutes as well. But here's also someone much earlier and way more influential on the views of the ratifiers, James Wilson, one of the first associate justices of the Supreme Court. Here he is arguing in the Pennsylvania ratifying convention that judicial review not only exists, is to be expected, but it's going to be awesome as well. And the debate wasn't really about whether or not it would exist, but how effective it would be at keeping the federal government in check. Again, Wilson, one of the first associate justices on the Supreme Court, nominated for the role by George Washington. Here he's in the Pennsylvania ratifying convention, says, and he's talking about, like, well, when something goes beyond the limits of the Constitution, what goes down? He says, but when it comes to be discussed before the judges, when they consider its principles and find it to be incompatible with the superior power of the Constitution, it is their duty to pronounce it void. So he's explaining to the people in Pennsylvania, and this was printed all over the place. All of Wilson's stuff was debated all over the place. And again, he's saying when they pass a law, is a statute greater than the Constitution? No, certainly. If you have a choice between one or the other, okay, I'm going to either uphold the statute, but the statute says it goes against the Constitution, or vice versa. You got to go with the Constitution. It's a duty to do that. We're going to get a lot more into duty and the oath of office as well. And then he says it's going to be great. This is going to be really effective. And judges, independent and not obliged to look to every session for a continuance of their salaries, will behave with intrepidity, and refuse to the act the sanction of judicial authority. But again, understanding if the judge is reading an act, a piece of legislation, and he sees that it does not fit within the bounds of the Constitution, he has two options. He's either going to give it sanction, so he's basically going to say, yeah, I approve of this unconstitutional act, and then give it more foundation in the general public, or he's going to say, no, this is unconstitutional. Those are his two options. And if you're taking an oath to the Constitution, that should be pretty obvious which one it is. Now, in response to James Wilson, not a single one of the anti-federalists in Pennsylvania actually disagreed that there would be a power of judicial review. There was just a debate, like I was saying just a minute ago, that it would be really effective. And there was a lot of complaint saying that it wasn't going to be effective. They just didn't think that under the structure of the Constitution, the way things were laid out in the various branches, was that it was going to work very well. And one prominent example was that the impeachment potential was going to thwart real judicial review. Now, maybe that didn't play out like that. Maybe Patrick Henry was right and he saw it as nothing more than really just a sham, the impeachment process. But anti-federalists in various other states said, well, how can you actually have independent justices if you have this power of impeachment? So this whole judicial review thing, they're going to be afraid to do it. They're not going to declare stuff void because they're going to be afraid that they're going to lose their job. And that was what the debate was going on about in Pennsylvania in response to James Wilson. We also have, for example, on the anti-federalist side, Samuel Adams in the Massachusetts Ratifying Convention. And he also recognized that this would be part of the system. He said, if any law made by the federal government shall be extended beyond the power granted by the proposed Constitution and inconsistent with the Constitution of this state. So he's really putting primacy of the state constitution in there as well. He said it will be an error and adjudged by the courts of law to be void. So Samuel Adams was also recognizing that the federal courts would come in and say, well, no, this is unconstitutional and therefore void. We know that the founding generation, one of the leading principles of the American Revolution was that government was only authorized to exercise those things within the bounds of its constitution or of the Constitution. For the American revolutionaries, they struggled with this because the British system was an unwritten constitution, and that's why they put words to paper. They fought a long, bloody war to get out from under the tyranny of an arbitrary government, one that, well, they didn't have very clear rules, and so this led to a lot of problems. Here's another example talking about this during the ratification debates. Oliver Ellsworth, who went on to become the third Chief Justice of the United States. He was the guy that I think stepped down just before Marshall was put in office. But here's how Ellsworth put it in the Connecticut Ratifying Convention. This is also in 1788, just maybe a few weeks before Samuel Adams. He said, if the United States go beyond their powers, if they make a law which the Constitution does not authorize, it is void. Again, that was one of the leading principles of the American Revolution, that as soon as they go beyond their limits, the act is void and no one is bound to obey it. And that's what the line in the sand is supposed to be about. But Ellsworth went further. He said, and the judicial power, the national judges, who to secure their impartiality are to be made independent, will declare it to be void. So the notion, again, that this came up out of nowhere, this was just popped out of Chief Justice John Marshall's mind, that he made this up in 1803, is absurd, especially when so many leading legal minds, we've got two people on the Supreme Court, Wilson and Ellsworth already, plus Samuel Adams on the anti-federalist side, Hamilton, and here's George Nicholas in the Virginia Ratifying Convention, all saying that they expected the courts to declare their opinions, saying that unconstitutional acts are just that and void. He said, if this is Nicholas, if they exceed these powers, the judiciary will declare it void. And if not, the people will have a right to declare it void. Getting into a little nullification there, George Nicholas as well. And then also on the anti-federalist side, George Mason, one of the most influential of the founders in the old revolutionaries. Here he is discussing ex post facto laws and pointing out, well, the judges are going to take care of this. He said, will it not be the duty of the federal court to say that such laws are prohibited? And here's Sentinel in his 16th anti-federalist essay. He said it would be their sworn duty to refuse their sanction to laws made in the face and contrary to the letter and spirit of the Constitution. Over and over and over again, anti-federalists acknowledged what the Federalists were telling them, that when cases came before the federal judges, if the federal judges felt that it was beyond the Constitution, they would say this is unconstitutional and void. And most of the opposition from the anti-federalists wasn't debating that this would exist. People like Patrick Henry, William Grayson, Federal Farmer, I believe as well, mostly argued that under the system as structured, judges would not have the backbone and the fortitude to actually do this. They were concerned that it wasn't going to happen enough. We saw similar takes from, Federal Farmer, I believe also Brutus, definitely Luther Martin in Maryland, and others. And then John Dickinson, the penman of the American Revolution, the lead drafter of the Articles of Confederation, and then later a Federalist supporter of the Constitution, one of the framers at the Philadelphia Convention. He had a really interesting approach because he was against judicial review in the Philadelphia Convention. He thought no such power ought to exist. He actually thought it was a bad idea, argued against it, lost the debate. But so here during the ratification debates, Fabius number 4, which I cite often about various other issues, this is April of 1788. He said, well, this is in it. This is one check on federal power. I guess he wasn't sharing his personal opinions that he didn't want it at that point because they were supposed to be keeping it secret. But he's telling the people, like, if you ratify, this is how it's going to play out. The federal independent judges, so much concerned in the execution of the laws and in the determination of their constitutionality. That would be another check on federal power. So just to sum up this first myth, judicial review was not created by Chief Justice John Marshall. It was expected by everyone in the ratification debates. The anti-federalists were worried it wouldn't happen enough. It was discussed in those ratification debates. From my reading on this, at least my history research, probably much more than what I found, somewhere around 36 to maybe 40 different times. And not one single time when it was debated and discussed, not once did anyone say, oh no, that's bull. It doesn't exist. We shouldn't expect it to happen. Again, the debate was whether or not it would be an effective tool to keeping federal power in check. And this was not just talk. It wasn't just philosophical. It's how the courts had been operating all along. And back to Nadelson's article, he said in the years before the first case in which the Supreme Court struck down a federal law, I don't like how he phrases that. He said void and he said struck down a federal law. Basically, it sounds like they have the final say just in that phraseology. And maybe it's because he's a really good legal mind and this is the kind of things that they're kind of inundated over time. But he's referencing Marbury versus Madison. He said there were over 30 episodes in which American courts had already done this, voided state or federal laws for unconstitutionality. So it happened almost 36 times before Chief Justice John Marshall supposedly created this whole thing. So let's get to the case itself. Marshall's opinion in Marbury versus Madison. This is important. He said it is, and this is a very famous phrase. He said it is emphatically the province and duty of the judicial department to say what the law is. And that's really the basis of where the entire myth starts. But almost everyone takes it completely out of context. They read that in a vacuum and they read it as saying it's emphatically the province and duty of only the judicial department to say what the law is, and then their view is binding on everyone else. And that's how they read that statement. And Mike Meharry, in this classic 10th Amendment Center article from, quite a few years ago, he discussed this in some detail. He points out that many legal experts rip this one sentence out of context from John Marshall's opinion and find in it the authority for the Supreme Court to stand as the exclusive and final judge on the extent of federal power. But, Mike writes, even if you accept this bizarre notion, I like how he puts this bizarre notion that a political body can vest power in itself on its own whim, this was not John Marshall's intent. That's not what he wrote at all. That's just made up. He said Marshall was answering a specific question. Does the court have the authority to consider the constitutionality of an act when ruling on a case? This was not, it was expected, but this was really the first big Supreme Court opinion that could be issued where he could actually put it to words and say, yes, we do have the authority to express our views on the constitutionality of something. It's our duty. We take an oath. And he talks about the oath quite a bit. Mike continues, at issue was a provision of the Judiciary Act and whether the court had original jurisdiction to decide if a writ of mandamus could be issued to force James Madison to hand over Marbury's commission. A quick side note. This is basically whether or not the federal court could tell the executive branch that they had to do something. And Marshall did not do that. He did not claim that power. It could be that he wanted to claim that power, but he knew he couldn't get away with it. It was very clear that had he tried to do that the Jefferson administration would have completely ignored it. They didn't even send anyone to defend their side in court. So Jefferson was very dismissive of this whole thing. And that says quite a bit as well. But anyways, Mike writes, some argued the court should just consider the law, the Judiciary Act itself, and not even question whether or not it was constitutional. Some people were taking that position. So Marshall defended his decision to rule based on the Constitution. That was very, very important. And he said, the judicial power of the United States is extended to all cases arising under the Constitution. Could it be the intention of those who gave this power, that is the people of the several states, to say that in using it, the Constitution should not be looked into? So seems like kind of a pretty obvious question. Why would they not think about whether or not something fits within the bounds of the Constitution and only look at the statute? Is this what Congress was intending here? And he's like, this is nonsense. He said that a case arising under the Constitution should be decided without examining the instrument under which it arises. That is too extravagant to be maintained. And one more time here from Marbury, he said, why otherwise does it direct the judges to take an oath to support it? This oath certainly applies in an especial manner to their conduct and their official character. Like, what's the point of taking an oath to support the Constitution if we're not allowed to consider constitutionality of an act or of a case that comes before us? There's no point. He said, how immoral to impose this oath on them if they were to be used as the instruments and the knowing instruments for violating what they swear to support. Because if you believe something to be unconstitutional and then you're not allowed to even say that it's unconstitutional, you can't even look to the Constitution, that means you've just become a tool to perpetuate unconstitutional acts. So it would be absurd to create a system like that. He said, why does a judge swear to discharge his duties agreeably the Constitution of the United States if that Constitution forms no rule for his government, if it is closed upon him and cannot be inspected by him? He said, if such be the real state of things, this is worse than solemn mockery. To prescribe or to take this oath becomes equally a crime. For Chief Justice John Marshall, this is a pretty big government guy. He did some bad stuff as Chief Justice. But for him to say, look, if you take an oath and you knowingly see something as violating the Constitution and you just let it ride, that's criminal. I'd like to see much, much more of that attitude in modern times. But anyways, we'll get back to that in just a moment. I want to first point out that everything that I'm referencing in this episode, various articles, some original source documents, law review papers, and the like, they will all be included in a blog post that we publish for every single episode over at 10thamendmentcenter.com/path-to-liberty. It's all spelled out, 10thamendmentcenter.com/path-to-liberty. Alan Mosley does an awesome job getting the blog post organized, the show links section, generally in the order that I go through it in each episode, so you can read and learn more in context on your own time, and I will get it published probably up to a couple of hours after this live stream is done. Again, that's 10thamendmentcenter.com/path-to-liberty. With that, let's get back to it. We were talking about the oath of office because Marbury was talking about the oath. What's the point of taking an oath if you can't consider the constitutionality of something when you're doing your job? The founding generation really took the oath to the Constitution much more seriously than anyone does today. Today, it is basically a sham. They are taking an oath to something that they know nothing about. Or if they do know something about, They have no intention of following it in most situations. But here Paulson writes, the implication of Marshall's argument from the oath requirement is obvious. Marbury is no argument for judicial supremacy and constitutional interpretation. That's nonsense. He said it is an argument for the personal constitutional responsibility of all who swear an oath to support the Constitution to resist and refuse support to usurpations or violations of that Constitution by all others. Again, to resist and refuse support. If you take an oath, that's what your duty is, not just a good idea. Now, if everyone starts out with and emphasizes their oath to the Constitution, then it's absolutely 100% the duty of everyone in every part of government at every level to follow their oath to the best of their ability every time the Constitution is implicated in any action that they're involved in. That's actually the foundation of real checks and balances under the Constitution. The way that we're told today that checks and balances is everybody kind of does whatever until the Supreme Court tells them to stop. That's not checks and balances. That's what Thomas Jefferson called the despotism of an oligarchy. So President Thomas Jefferson described how it plays out like this the year after Marbury versus Madison in a letter to Abigail Adams. He said, "You seem to think it devolved on the judges to decide on the validity of the sedition law, but nothing in the Constitution has given them a right to decide for the executive more than to the executive to decide for them. Both magistracies are equally independent in the sphere of action assigned to them. And this is what happens when the different branches disagree on the constitutionality of any particular act." He said the judges, believing the law constitutional, had a right to pass a sentence of fine and imprisonment because that power was placed in their hands by the Constitution. So no one else outside the judiciary could make that determination. He said, but on the other hand, the executive, believing the law to be unconstitutional, was bound to remit the execution of it because that power had been confided to him by the Constitution. That instrument that meant that its coordinate branches should be checks on each other. So again, Jefferson explaining how this play not only is supposed to be, but how it played out in response to the Sedition Act of 1798. The courts thought it was constitutional and passed a judgment of fine and punishment. The executive thought it was unconstitutional. He said it was a nullity. He said there's no way I could ever do this. In many letters over the years, there's no way I could enforce it. It was my duty. Again, it gets down to the duty because it's an oath to the Constitution and it's his duty. There's no way he could ever give sanction to an unconstitutional act because, as John Marshall even put it, that would be a crime to do that. Now, I covered this whole system of real checks and balances in the Founders Constitution in an episode just this month, Ignore the Court, the real checks and balances in the Founders Constitution. This doesn't mean always ignore it, but ignore it in the kind of the framework of you're supposed to follow it just because the court said something. It really starts with the Constitution. It ends with the Constitution. And in the middle is the Constitution. That will be linked to, of course, in the show notes, 10thamendmentcenter.com/path-to-liberty. So again, if we start with the oath, as we're supposed to do, it should be obvious that it's the job of a judge to give their opinion on the constitutionality on anything that comes before them. And Mike Meharry makes an important point on this as well. He said, but notice an important point. Nowhere does John Marshall assert that the court stands as the sole or final judge of constitutionality. In fact, he maintains that the Constitution also binds the court itself. So the Constitution is above all the branches of government. And then, as James Wilson also explained, above the Constitution is the people of the several states. Here's how Marshall put it near the end of Marbury. He said, it is also not entirely unworthy of observation that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution have that rank. So he's really establishing here constitutional, not establishing, reiterating constitutional supremacy. He said, thus, The particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and the courts, as well as other departments, are bound by that instrument. So he's really hammering that home. Back to Paulson, he says, with this, the logic of Marbury implies not, as is so widely assumed today, judicial supremacy, but constitutional supremacy. People of the states, Constitution, government people. That's the government people on the bottom, and that includes the judiciary. So constitutional supremacy, the supremacy of the document itself over misapplications of its dictates by any and all subordinate agencies created by it. As a corollary, he writes, Marbury also stands for the independent obligation of each coordinate branch of the national government, federal government, I don't like that term, national, to be governed by that document rather than by departures from it committed by the other branches. You can't give sanction to unconstitutional acts or you violate that oath. Now back to Marshall and Marbury. He said the Constitution is either a superior, paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, is alterable when the legislature shall please to alter it. So either the Constitution is supreme and everybody who works in the government is just an agent of the people who created that Constitution, the people of the several states, or it's just like whatever other act, they pass it, they repeal it, they amend it, they change it, whatever. And he's like, no, this is again nonsense. He said, certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation. And consequently, the theory of every such government must be, again, that an act of the legislature repugnant to the Constitution is void. Of course, they just have to treat it like that, too. He said this theory is essentially attached to a written constitution and is, consequently, to be considered by this court as one of the fundamental principles of our society. It is not, therefore, to be lost sight of in the further consideration of this subject. Again, the Constitution is supreme, not the opinions of the judges about the Constitution, because if the framers wanted that to be that way, they would have put that in the Constitution itself. And then back to Paulson, he describes it like this. This fundamental principle of constitutional supremacy is, however, lost sight of in almost all further consideration of the subject of judicial review by today's academics, judges, lawyers, and students. Basically, everyone just takes one line in a vacuum out of context and then reads it completely wrong. They make up stuff to basically give one branch of the federal government superiority over everybody, despite the fact that no one in the founding generation considered it that way. Even though some people wanted something like that, no one sold it like that. Paulson said they rushed to a line that shows up a few paragraphs later in the opinion. It is emphatically the province and duty of the judicial department to say what the law is, but wrench it from context. Marshall's argument, he said to this point, has been that the written Constitution prevails over the inconsistent actions of government, or else the Constitution is meaningless. Back to Marbury. Again, he asked the question, well, what happens if something is void? He said, if an act of the legislature, so he's first establishing this principle that everyone understood. As soon as you go beyond the limits of the Constitution, it's void. There's so many examples. He didn't have to cite them all throughout the Revolution, throughout the ratification debates, and beyond, where everyone agreed on that principle. So he said, well, if an act of the legislature repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? So is there anything that requires them to say, yeah, go for it, I'm sanctioning this in my job? No, because he take an oath to the Constitution. He said, or in other words, though it be not law because it is void, does it constitute a rule as operative as if it was a law? He said this would be to overthrow, in fact, what was established in theory and would seem at first view an absurdity too gross to be insisted on. And yes, it is an absurdity. Paulson says nothing in Marbury, not one iota, not one word, not one sentence, nothing. And of course, it'll be linked to in the show notes. You can read it. Nothing supports the modern myth of judicial supremacy in interpretation of the Constitution. Again, quite the contrary. Marbury's holding of judicial review rests on premises of separation of powers that are fundamentally inconsistent with the assertion by any one branch of the federal government of a superior power of constitutional interpretation over the others. Absolutely nothing in there gives us the modern version at all. If you just read the thing, back to Hamilton and Federalist number 78, he said, some perplexity respecting the rights of the courts to pronounce legislative acts void because contrary to the Constitution has arisen from an imagination that the doctrine would imply a superiority of the judiciary to the legislative power. So here, Alexander Hamilton, the biggest of the big government people at the time of the founding, he was the guy. He's saying, like, okay, I know there's this debate, and he's debating with Brutus and others here in Federalist 78, 81, etc. Here specifically in 78, he's like, some of you are pretty alarmed that this is going to lead to the judiciary being superior to the other branches. He's like, no. He said, it is urged that the authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void. But he's rejecting this as well. He's taking the same position that Jefferson took in that 1804 letter we cited just a little while ago. He said there is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. Again, reasserting that same principle. He said to deny this, if you take any other position, this is what you get. This would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. And just like Chief Justice John Marshall, I got a lot of problems with a lot of the stuff that Hamilton did, but when he was really on, he was really, really good. And that's a great explanation of how you have to reject judicial supremacy. And when even the biggest big government guy at the time of the founding rejects it, the fact that so many people today love it or think that's the only way things could be tells you how far things have gone off the rails. Anyways, he continued. In other words, the Constitution, he said, so from there, he actually went to what would happen when a case came before judges and there was a conflict between what was in the legislation or the statute and the Constitution. He said, well, look, the judge has to side with the Constitution, and that's their job. He said, in other words, the Constitution ought to be preferred to the statute, the intention of the people, which is the Constitution, to the intention of their agents, which are the acts of government. So always start with the Constitution. And then Hamilton summed it up with this. Nor does this conclusion by any means suppose a superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature, declared in its statutes, stands in opposition to the will of the people declared in the Constitution, the judges ought to be governed by the latter rather than the former. And again, this is Hamilton explaining constitutional supremacy totally at odds with what we have today, judicial supremacy. And here's longtime friend of the TAC, Publius Hulda, in an article we published from her a few years ago, clearing up the confusion about Marbury versus Madison. Of course, that'll be linked to in the show notes. She said, so what's the logical implication of all this? She said, when an act of Congress violates the Constitution and the issue is brought before a court in a lawsuit, it is the sworn duty of the court to side with the Constitution and against Congress or whatever. It's always their duty. She said, otherwise, what do you want the court to do? Do you want them to side with the Constitution or do you want them to side with Congress? And Joshua Dunn over at Teaching American History makes an interesting point. Marbury versus Madison does say that, quote, it is emphatically the province and duty of the judicial department to say what the law is, but it does not say that it is only the province of the court. That's kind of what I was getting to a little while ago. And then just kind of to reiterate what I was mentioning as well, the Jefferson administration in Marbury versus Madison, he said, did not even bother to send someone to present the administration's case. They just were like, what? What are you going to tell us to do? You can't tell us to do nothing. And that's probably, maybe politically, that's part of why Marshall didn't even try to. See, he didn't establish that he could issue this writ to Mr. Madison or to the Jefferson administration, because he knew that would really make it very obvious the precedent of maybe something he didn't want. I'm not sure what the motives are, but I guess there's other possible reads of why he did things. And here's how Paulson summed it up. The myth of judicial supremacy that stands at the center of constitutional law today, the notion that the Supreme Court's decisions are final and binding on all other actors in our constitutional system, no matter what, so that all that really matters in constitutional law is the Supreme Court's decisions and precedents, is utterly groundless as a matter of first principles of the Constitution. If you believe that the Constitution means what the Constitution means, that means sometimes, as James Madison, Thomas Jefferson, so many others told us, that sometimes, well, the judiciary may make mistakes. But if you believe in judicial supremacy, then the Constitution means what the courts say it means until it changes its mind, no matter how wrong they may be. They could say, oh, that whole Second Amendment thing, well, they didn't really mean anyone could keep and bear arms. They just meant, they could work out, pump some weight. I don't know a better analogy, but they could say something completely absurd. And if you believe that they have the final say in all times, then that would be the Constitution. What's the point of having a Constitution? Just have a bunch of precedent, live off of precedent. And that's kind of what we live under. Paulson says this myth finds no support in the text, structure, or history of the Constitution. Instead, it rests on a complete misreading of the case that is supposed to be the source and justification for the myth, Marbury. And I think much of the myth is a confusion over the terms judicial review and judicial supremacy. I've seen even friends of the TAC say, oh yeah, this whole judicial review thing is bad. I mean, again, the question is, do you want the judiciary to give sanction by not even considering the Constitution, give sanction to unconstitutional acts, or do you at least want them to put the word out there, hey, this is unconstitutional and why? It's just that they don't bind the actions of the other branches, the states, etc. That's the difference between review and supremacy. So if we take the real reading of Marbury versus Madison, you just read the text, read what Marshall wrote, and if we just take it for what it really said, we actually get a number of really big changes, big implications and changes compared to how things play out in modern times. First of all, everyone who takes an oath, everyone, state, federal, whatever, they take an oath to the Constitution. They don't take an oath to the opinions on the Constitution of any other person, alive, dead, or ever. 2, judges don't have the final say over the meaning of the Constitution. As I've mentioned on this episode and others, Thomas Jefferson specifically said that would put us under the despotism of an oligarchy. 3, the doctrine of stare decisis, if you're familiar with that, that's basically the practice of generally adhering to court precedent, whether or not it is mistaken rather than the Constitution. Well, that doctrine is totally unconstitutional as well, because if you take an oath to the Constitution, you're taking an oath to the Constitution, not the opinions of someone who been issued on the Constitution 5 years or 100 years ago. And then 4, it also gives us support for the doctrines of nullification and interposition, because everyone in state government also swears an oath to the Constitution, not to the federal government and not to the opinions of anyone in the federal government. So if people take an oath and they see something as unconstitutional, it is their duty, like Thomas Jefferson said in response to the Sedition Act, to remit execution of the act wherever they can. And so it is their duty to oppose, resist, and refuse to give sanction to any unconstitutional act of the government. And it's, again, It starts with the oath of office, and it starts with constitutional supremacy. And I think, hearing just even some of this, there is way, way more that you can read and learn more about, which is why we put all the reference links in the show notes at 10thamendmentcenter.com/path-to-liberty. I think it should be no surprise at all why the government-run schools never teach any of this. Why we started out with the official website for the federal judiciary telling us the total myth, just a complete lie. They're telling us that they have final say and more power than anyone ever said that they ever had, including Chief Justice John Marshall. And so that's why we work so hard here at the 10th Amendment Center every single day, rolling up our sleeves and trying to reach and teach more people about the original legal meaning of the Constitution and how to defend it when government refuses to do so, which is 24/7, 365. And absolutely nothing helps us do this work more than the financial faith and support of our members. If you appreciate the work that we're doing and you want us to continue and expand on it, please consider joining us today. It's as little as $2 a month. So that dirty government fiat that they keep devaluing, if you got a couple of bucks of that, please throw it our way. We also have annual, 5-year, and lifetime options at 10thamendmentcenter.com/members, all spelled out, 10thamendmentcenter.com/members. You can also make a one-time gift if you prefer that instead, or if you've already joined us as a member and you want to pitch in a little bit more, no pressure, but you can go to 10thamendmentcenter.com/donate to make a one-time contribution to help us out. I'm not going to belabor the point, but I'd be extremely grateful for any consideration you can give to putting your financial faith behind our work here today. There's a number of other free and easy peasy things you can do, like hitting the like button, leaving reviews on Apple Podcasts or any other podcast platform, subscribe, get notifications, comments, the percentage of watch time on the videos. That really helps out a great deal. All those things can trigger the algorithms of the mainstream platforms and tell them to show us to more people. We are reaching not nearly enough, but way more than I ever thought possible when I first registered the domain name 10thamendmentcenter.com back in June of 2006. So I'm very grateful for your support. I really hope you enjoyed this episode. I hope that I made some of this pretty deep info at least interesting and entertaining here and there. But more importantly than anything, I hope you learned something. I hope it made you think. That's really the top thing, that this was educational. Again, I really appreciate you being here. I hope you have an awesome day, and I look forward to seeing you next time here on the Path to Liberty.